What's up, everybody? Thank you for tuning in to another episode of the CPA Zone, the podcast where we discuss tax strategies and accounting tips for entrepreneurs and real estate investors. My name is Ryan Pulis, and our company, the Pulis Group, offers tax planning and advisory services for entrepreneurs like you. Whether it's bookkeeping, tax planning, or CFO services that you're looking for, we've got you covered. What's up, everybody? Welcome to another episode of the CPA Zone. Today we're going to talk about another tax court case. This one involves real estate professional status, short-term rental, the grouping election, and how that applies to your traditional long-term rentals and short-term rentals. So this case it's Bailey versus Commissioner. This is Tax Court Memo 2001-296, and it's from 2021. Involving tax years 1996 and 1997. So what happened here? We have a married couple, Bruce and Judy Bailey. They're both attorneys, and they own, looks like 4 different rental properties. So on their 96 and 97 return, they took the position that Judy, the wife, was a real estate professional, where she also worked as an attorney, and that she materially participated in their rental operations. Now, what we see here is that in 1996 and 97, both were practicing attorneys. Judy's the one claiming real estate professional status, so we have a bit more information on her. They have 4 rental properties. It looks like a condo. They call the Indian Wells condominium. A unit in another development called the Indian Wells unit. 2 fourplex buildings that is referred to as the Elderwood properties. And then a single family home in Caribou Drive that they call the Lake Arrowhead property. That's the Lake Arrowhead property that is the short-term rental. We'll see a bit more about that shortly. They made an election in 1994 to group all of their real estate rentals together as a single activity. Once you make that election, it is good indefinitely until something changes. And if you request to have it revoked or the IRS revokes it. Now, the taxpayers here it does say that Judy kept daily calendars for both 1996 and 1997 that had various appointments related to her law practice as well as her real estate activities. This is just her calendar. During preparation for trial, she created a separate summary report with her based on her calendars for 96 and 97. And she provided an estimated total number of hours spent on the rental properties. Now, the summary report just gave a general list of the legal activities as well that she performed during the year. She estimated that she spent 876 hours in the law practice during 1997. And she also maintains that she spent, it's like 311 hours in one property, the Indian Wells properties. So I guess we have the two Indian Wells properties put together is 311 hours. Where she had a summary of what she did is rented, cleaning, gardening, showed the property to prospective renters and expected repairman's work. Another 412 hours on the Elderwood property, which was looks like it was vacant during the tax year, where she said she arranged for preparers, did the gardening and some cleaning. And then on the Lake Arrowhead property, short-term rental. So we got 311 and 412, so that's 723 hours. Lake Arrowhead property, she's claimed she spent 197.5 hours in 96 and 214 in 97. Now, in this property, we're told that the average customer use of the Lake Arrowhead property was 5 days in 96 and 3.8 days in 1997. So it does qualify as a short-term rental. That's going to be key here because in her mind, she's adding these hours up. When you add in the 214 hours from the short-term rental, looks like she might have a little bit more than what she had in her law practice, which becomes key when trying to hit real estate professional status. Now, she had a commission agreement, which another term for property management agreement, with a group called Mountain Country Realty that handled the Lake Arrowhead property. So they had a property manager in place for this short-term rental property. Remember, having a property manager makes it very difficult to show material participation. So they deducted these losses in 96 and 97, claiming she's a real estate professional, and they also claimed that they materially participated in their short-term rental, which we'll get to here shortly. Now, the IRS came back and said, no, These activities are all passive. She does not qualify as a real estate professional. The Arrowhead property is a short-term rental because the average period of customer stay is less than 7 days. That is separate from the other rentals. No grouping is allowed. So IRS is telling them, look, your rentals are passive. You don't qualify as a real estate professional because, one, we don't believe the hours that you're putting forth because there's no contemporaneous time logs. These are after the fact ballpark guesstimates, which we don't have to accept. And even if we did take all your hours and find them reasonable, because the Arrowhead property is a short-term rental, those hours do not count in the grouping of your rental activities because under the passive activity loss rules, an activity where the average period of customer use is 7 days or less is not a rental property. Therefore, those hours don't get grouped with your other rentals for purposes of trying to hit the 750 hours for real estate professional status or showing more than 50% of your time in real property trades or businesses. So remember, to qualify as a real estate professional, those are the two hurdles. You have to have one half or 50%, more than 50% of your time spent in real property trades or businesses, and you perform at least 750 hours of services in real property trades or businesses. Now, on a joint return, one spouse has to pass both tests on their own. There's actually no mention of the husband's time on this, so they either didn't bring that up or maybe he just wasn't involved. But she did not pass those two hurdles to qualify as a real estate professional. And the IRS is telling them, we don't agree that the short-term rental hours get grouped in, which that blows up the 50% test in the 750 hours. Without the short-term rental hours, she does not pass. Now, they also are saying they don't agree with their hours. They don't believe them. They feel like they're inflated. There's no real proof of the activities they did. They haven't substantiated their hours by a reasonable means, is what the IRS says, and the tax court does agree with them. The taxpayers in this case lost. So when you take out those short-term rental hours, they don't, even if they believe them, they're telling them the short-term rental hours don't count. So even if we believed your hours, they are not enough when you take the short-term rental out of it to qualify as a real estate professional. So then they go on, the taxpayers argue, well, we still should be able to deduct the losses from the short-term rental because we materially participated. Now, remember, material participation, there's 7 tests. You can participate 500 hours or more during the year. And participation here means, any work done by an individual that owns an interest in the activity is participation. So you can participate more than 500 hours. Your time is substantially all, so you're basically doing everything yourself. You participate for 100 hours and more than anyone else. It's a significant participation activity. We're not going into the details of that. It's not going to apply here. Basically, you need multiple activities grouped together. And when you combine them, they exceed the 500. There's you materially participated for any of the past, or you materially participated in any of the 5 of the last 10 tax years, or if it's a personal service activity, you materially participated for any 3 years, whether or not consecutive, prior to the current tax year. Neither of those apply here. And then the test 7, based on the facts and circumstances, which they don't pass, there's also a minimum of 100 hours there, and you cannot have a property manager in place for that. So they put forth that their time spent on the short-term rental in 1996 was 197.5 hours and 214. So they thought they'd pass under test 7, the facts and circumstances, or test 3, 100 hours or more than anyone else. However, they had that property manager in place. That property manager, they had no way to prove their time. So they weren't able to show that they participated 100 hours and more than anyone else. They didn't have the property manager hours to support. And the IRS still didn't believe the hours they were putting forward for the 197 and the 214. Anyway, again, they didn't have contemporaneous time records. So the taxpayer lost in this case for both tax years. So again, this just reiterates how important it is to really maintain those time logs as you go. Even if you qualify as a real estate professional and you have the material participation, you need to have the documentation in place to prove it, or odds are the IRS is not going to give it to you. They're going to push back, and if you don't have the supporting documentation, you are not going to win. You don't want to go to tax court to try to win in trial anyway, because it's very expensive. So get that support in place early on so you don't run into these issues. And no, your short-term rental hours, well, I don't really agree this is the appropriate interpretation, if you will, but the tax courts have ruled those short-term rental hours are not technically rental activities, so you can't combine them with your traditional rentals. Well, that about does it for today, our discussion on Bailey v. Commissioner. There's actually another Bailey case out there that the tax court found the same thing with short-term rental hours not counting. But maybe we'll talk about that on a future episode. For now, I hope you found value in this episode. If so, please leave a 5-star review and hit that like and subscribe button. Until next time, have a great day.
This audio segment was edited by me, Adam Rothstein. If you would like help editing your podcast or narrating your audiobooks, please email me at adamrothstein29@gmail.com. That's ADAMROTHSTEIN29@gmail.com.
So that about does it for this episode of the CPA Zone. Thanks for listening, and I hope you found something valuable that you can take away. We are taking on new clients, and if you'd like to work with us, then go to our website and fill out the client intake form on our contact page. This can be found at thepulisgroup.com/contact. That's THEPULICEGROUP.com/contact.